Any mention?
But here under 223.
Please, Lordship. Lordship, back to mention item number 33, Lordship. Mr. Shilla is still on medical leave, Lordship. Kindly allow us 2 weeks' time.
Who's the senior?
Mr. Shilla,
He's not come back.
He's not back yet, Lordship.
Lordship, yes.
Yes. The request also due to illness of the arguing counsel. Yes, after 3 weeks or 2 weeks?
3 weeks, Lordship.
Okay. Yes.
Obliged.
Yes.
May it please your Lordship. Lordship, with the consent of the other side, I beg to mention item number 30, Lordship. 28, 29, 30, they are connected matters. In item number 30, during the course of the day, I will file our rejoinder, Lordship.
Rejoinder.
Yes.
And writ petition.
The writ petition? Okay. 28, 29, 30?
Yes, Lord.
Connected matters. The doctors.
After 2 weeks, okay.
Lordship, much obliged.
Lordship, I beg to mention item number 35, Lordship. Yes, sir. Lordship, conducting counsel is not well.
What about you? Received that information? You applied for it?
Yes, Your Lordship, we have received, Lordship.
You received information?
Yes, sir.
What does it say?
Lordship, actually, we just received recently, Your Lordship. We'll
You
file.
read it also?
No, Your Lordship.
Okay, after 2 weeks.
Item 35, we have already placed the report.
No, they wanted to know when was the report placed in the assembly and what was the discussion made on the basis of the report. That's all, yes.
Oh, maybe we may be allowed to file a affidavit, Your Lordship, to bring on record the information.
You take a call.
Yes, sir.
Do we hear it a bit? Yes.
So for item number 38, Your Lordship. So we're supposed to file affidavit, Your Lordship, but we need some more time, Your Lordship.
What affidavit at the hearing stage?
No, Your Lordship, because as per the last order, Your Lordship, we have
What was the, why we asked to file affidavit?
because the respondent number 5 has been recently issued notice, Your Lordship. So last date we enter appearance, Your Lordship.
For the district council?
Yes, Your Lordship. Respondent number 5.
Who's number 5?
He's
a joint secretary,
joint
Lordship, and
secretary.
he was the person who issued the impugn order.
Okay, yes, after 2 weeks.
Lordship, the matter may come up in the orders column.
Yeah, after 2 weeks for affidavit by respondent number 5. This is the order column, next stage, yes.
Obliged.
Obliged.
May I proceed, Lordship? Item number 41. My conducting counsel is not well, so matter may be taken up for 2 weeks.
Who's conducting counsel?
N.M. Mansuri.
I'm for the private response. Lordship, I beg to mention 2 matters to be listed today, Lordship. Unlisted motion, Lordship.
Why? What's the urgency?
This is a cancellation of PDS license, Lordship.
Same matter, or they cancel now?
My one cancel, Lordship, yes.
You moved one last week?
No, I didn't move. My friend that Hassan has moved 2 matters, Lordship.
My lord, I have moved mine.
So he's
been cancelled meanwhile?
No,
mine 2 other, the petitioner I have challenged, that 2 has not cancelled yet, my lord.
So you challenged it, that's why I did not cancel
There
it.
is other.
my one already cancelled on the last.
So there's no urgency, it's already been
There is
cancelled.
urgency because what I am apprehending, my lord, because they might appoint that third party,
And
Lordship.
what was the real point?
My lord, that is the instruction I have, Lordship. That is only the concern, Lordship.
That means it's high government efficiency if they can appoint, cancel and appoint same day.
Cancellation was 6th, Lordship. 6th of this month, Lordship. It is not that cancel just.
So let this matter be listed tomorrow so that I ask the department to take instruction.
They'll come tomorrow. Since 6 and cancelled.
6 cancel, Lordship.
Then you've come now only.
No, my lord, 16, that order was delivered on 16. Then 17, I have filed representation before the DC, Lordship.
Tomorrow.
Because he was in between, he was on leave, Lordship.
Tomorrow.
Item number 1.
Well, Bora. Yes, Bora, I've taken instructions. You would draw and file in Guwahati.
No, my lord.
Why?
My lord, what learned counsel has said is regarding 226 before 1963. After that, when
Before?
1963, when it was amended and clause 2 had come.
Which case is submitting?
My lord, in support, I have a
No, what case? Subodh Kumar Ray.
Subodh Kumar Rai.
Yeah, what's the case? It's on jurisdiction.
Yes, regarding jurisdiction.
Yeah.
Now here, the case is that.
You're sure you're arguing the same case?
Yes, same case.
Same case before us?
Yes.
Okay. Yes.
No, actually, my client is making copy of this ruling. I'll submit. Here, this is a judgment from Division Bench of Madhya Pradesh High Court. That is the latest I found of 2024.
What does it say?
This is also regarding jurisdiction. What happened? Two persons, they had a termination letter or something from their office at Bhopal, and they filed the writ petition at Jabalpur.
Bhopal and Jabalpur in the same state.
They have
They're just different benches. Bhopal is no bench. It's only Indore and Jabalpur that is a bench.
Yes, they filed in Jabalpur bench.
Yes.
Bhopal is the main seat.
The same state. There's no issue about that.
And that is what the single judge had asked the persons to withdraw the case and file it in the other Jabalpur. The division bench then took the matter,
Sorry.
and
Just listen to the court. Jabalpur, Bhopal, Indore in the same state. Now what has happened here? Suppose you file in. Suppose now Guwahati High Court is a bench in Itanagar, correct? Nalagun. Suppose you file there, and then they take it up and they say no. The cause of action rises. Guwahati says okay, you can do it. It's common High Court.
This is under Article 226, my lord.
226, but in this case, Mr. Bora, I don't want to dismiss this case. Appointment order was given to you in Assam.
Now the jurisdiction matter as per this High Court, and this High Court has taken reliance of several Supreme Court cases also.
In this Jabalpur case?
In this case.
It is not, that is same state.
And three questions had been formulated, my lord.
Yes.
These questions are, number one, whether a writ petition would be maintainable before the bench within whose territorial jurisdiction the order impugned in the writ petition had been issued, even though the order affects an employee who is posted in the territories outside the territorial jurisdiction of the said bench. That is one question.
Not the state.
Second question is whether a writ petition can be filed based solely on the seat of the authority in cases where the cause of action or part thereof arises outside the territorial jurisdiction of the seat of the authority.
See,
this
Mr.
point.
Bora, please understand, that is the same High Court, MP High Court. Here talking about Guwahati High Court and Meghalaya High Court.
No.
I'm sorry.
In that case, my lord, I may be heard. With that case, the court has generalized the whole thing and given a formula sort of thing. Third question formulated by the court, my lord.
I don't know how to make you understand.
My lord, I may be heard. Third question is whether the principle of forum convenience has to be tested from the standpoint of the petitioner or the state government while entertaining a writ petition. This is what I'm stressing upon. Forum's convenience.
You give the judgment, we'll pass order.
Yes. I'll give it a copy. Now, I'll read the answers also.
Yes.
Three answers have been given. In answer, the questions raised in these appeals are thus answered as follows. After discussing several judgments of the High Courts and Supreme Court, these answers have been given. Number one answer, a writ petition would be maintainable before the bench within whose territorial jurisdiction the order impugned in the writ petition has been issued, even though the order affects an employee who is posted in territories outside the territorial jurisdiction of the said bench. That was in this case actually.
This is not applicable.
Second, not applicable. Now, second is, a writ petition can be filed based solely on the seat of the authority
This is not applicable.
in cases where the cause of action or part thereof arises outside the territorial jurisdiction of the seat of authority. Because cause of action starts from issuance and it culminates at the receipt of the impugned order. Third is, principle of forum convenience has to be tested from the standpoint of the petitioner, who is the dominus litis, and not at the convenience of the state government. Third point, the forum convenience has to be considered from the point of view of the petitioner. He is from Meghalaya. He had appeared in the recruitment rally in Meghalaya. He got posted in the group center. Well, the thing is that according to the application offered, he had joined on 28 December, but later, by the impugn order dated 8/4/2005, which has been issued and addressed to the petitioner.
Okay. The thing is that, look.
This was addressed to the petitioner in Meghalaya. Now, cause of action started where it was issued and it completed where it was received.
Yes.
And the infringement of fundamental rights was felt at Meghalaya when he received the impugned judgment. So from the point of view of the petitioner, considering the doctrine of forum convenience, his petition can be entertained by this honorable court.
Yes.
Well, may I refer to 226(3)(2), my lord. It says, my lord, the power conferred by clause 1 to issue directions, orders or writs to any government, authority or person may also be exercised by the High Court, exercising jurisdiction in relation to the territory within which the cause of action wholly or in part arises.
Cause of action.
So, my lord,
Whether if it
this
is
a
partly
case, my lord,
also
whether neither any part of cause of action is arisen in Meghalaya, my lord, nor the respondents are the office of the respondent.
The judgment says even if partly cause of action happens, the petitioner has a choice to go there also, considering doctrine of forum convenience.
If you're so interested in giving your client relief, what can we do? Take down. Yes, we've heard you. Heard Mr. P.K. Bora, also Dr. N. Muzikal at JCI. Stop. The petitioner in the instant case was appointed to the post of Constable Bugler in CRPF, and as per the submission of the council, had reported for training on 28/1/2025 and conducted the training program. Stop. On 14/4/2025, the petitioner had applied for 2 days leave, and on returning back, when is the cancel order? Right, order dated 8/4/2025.
23.
The appointment of the writ petitioner was cancelled on the ground that he had never reported for duty to the group center on 22/2/2025 as directed. Stop. Mr. P.K. Bora, if I put little counsel for the petitioner, has submitted that though the appointment order had been issued by, where is that? Where is the appointment order?
Page 17.
Where is that?
Page 17, Lecture 8.
Had been issued by the Office of the Deputy Inspector General Police, Group Center, Central Reserve Police Force, 9th Mile, Guwahati, Amerigo District, Kamrup, Assam. And though the writ petitioner reported for duty to the group center at Jorabad at Guwahati, he being a resident of Meghalaya, the writ petition would be maintainable before this court, and that would be good under Article 226 of the Constitution. In support of his submissions, the council has raised reliance in the case of so and so versus so and so reported in so and so, wherein he submits that in the cited case, the petitioner therein, a resident of Bhopal,
yes,
had preferred a writ petition
at Jabalpur,
the bench at the principal seat of the High Court of Madhya Pradesh in Jabalpur, and in spite of and on this, and no objections were raised as to territorial jurisdiction of the bench, it was held that the principle of forum convenience, CUNVENINS, has to be tested from the standpoint of the petitioner, who is the dominus litis, DOMINUS LITS, and not at the convenience of the state government. He therefore submits that the petitioner, Prohibitions and Meghalaya, though the appointment may have been issued in Guwahati, and he had reported for duty in the group center at Guwahati itself, the representation for this High Court. Next paragraph. Dr. N. Mozika, Learned Senior Counsel, ESGI, has refuted submission and submitted that none of the cause of action has arisen in Meghalaya, and even the principle laid down in the judgment so placed will have no application, as it is refers to convenient state government. In the instant case, the appointment is done by Central CAPF as CRP, and as such, there's no jurisdiction. Stop. Having heard the counsel for the parties, the peruse and materials, it is seen that the appointment orders issued from these group centers and CRPF 9-man Guwahati. The red petitioner also was, after allegedly joining, was serving in the group center there and attached to the
group center. I was there. I was attached as orderly of the deputy commandant.
Was attached to as an orderly to the deputy commandant, and even the cancellation of appointment for the post of constable has been issued from the group center itself. Stop. In the entire chain of events, apart from the fact that the petitioners resident of Meghalaya, no other materials are there to support that this court has jurisdiction over the instant matter. Accordingly, the petitioner has liberty to approach the jurisdictional High Court. Yes, matters are disposed of without inflicting cost. That judgment is a bench. Yes, next.
No, my point
yes,
is that
it's over, Mr. Bora. Yes.
Item
Don't
number,
deprive your client relief. Yes.
item number 2.
Yes. What is this?
This is against the prolonged suspension, Your Lordship, even after expiry of 90 days.
Contempt, what happened to contempt?
That has been closed, Lordship.
Okay, take notice. Yes, sir, issue notice. MS Ibla as present acceptable. All we have all the respondents. No surrenders called for. List after 2 weeks for instruction of affidavit.
Item number 3. This matter, my lord, will take it up or not? My lord has appeared.
Yes? No, I can't case before any other bench.
Item number
yes, Commission,
4.
same matter. Dissolution matter?
Dissolution.
My lord, this writ is preferred for refund of security deposit which was furnished in a seizure case. Which was
what was seized?
This is a battle nut, my lord. It was set aside by the tribunal and department is accepted.
What refund are you claiming?
Only 2,25,000. So security deposit.
You refunded, Mr. Mozika, Dr. Modi, when?
But I have example. 2 weeks time.
Similar order was passed by your court at para 4 of page 56.
Yes.
It is noted that Sujit Rai, though stated to be the son of the writ petitioner, is not before this court, and a prayer has been made on his behalf by his father, the writ petitioner. However, Sri Sujit Rai not being joined as a formal party, no relief can be forthcoming in the instant writ petition. As regards the writ petitioner's case, the respondents are directed to refund the release security deposit which has been furnished at the time of provisional release of the vehicle of the above mentioned name.
Yes, take down, heard Mr. N.S. Gupta and the council petition issued notice, Dr. N. Mozika, And the DSCI is present on behalf of sole respondent. No further notice is required. Stop. Mr. Ansugupta has submitted that the incident petition is connected to WPC number 393
Yes.
2024, where this court ordered it 9/5/2025. As your father?
Yes, father.
With regard to the patient's father, this court had directed for a refund of the security deposit. Stop. He submits a similar prayer. He has been made in this case. Stop. As he was not, or in this case, as he was not joined the formal party in the earlier petition. Having heard in counsel for that party, when can it come instructions?
A week's time.
Just after 1 week.
Much obliged.
Deep.
Number 5.
What is this?
Here, my lord, petition was settled with a contract, my lord. That is for printing of smart card based trading license, my lord.
When was this settled?
It was 23, my lord. I'll just take
By
a look.
open tender?
Well, this was through presentation and price negotiation, my lord.
Okay.
Page 13, my lord.
1-3.
1-3, my lord.
Mr. Kharsad, you're there for this for?
This, respondent 1 to 3, Your Lord.
1, 2, and 3.
Yes, on behalf of TT Dingdor.
Yes. This one, 4. Oh no.
Page 13, my lord. This is dated 12th of May 23.
Yes. Yes.
Now, my lord, clause 1 it says, I'll just take to clause 2, my lord, towards the bottom. The second party shall print the smart card based sticker trading license only to those applications, both fresh and renewal, which has been duly approved by the authorities of the council, and the hard copy of the license bearing the signature of the licensing officer or any of the officers shall be sent to the first party. So basically, the job was for printing the ATM type cards, my lord, for trading license. And lordship will see that tender contract period was 5 years, clause 11, my lord.
23 clause?
Clause 11, next page, my lord.
Okay. Well, when was it settled?
In 23, my lord. This is the 12th May 23.
You're continuing now?
I'm continuing, my lord. Contract was for 5 years. Now, suddenly, my lord, out of the blue, this letter comes, my lord, April order. It says, my lord, in inviting a reference to the subject cited above, I am delighted to inform that the Executive Committee, KHDC, has decided that the preparation and printing of digital smart card so-and-so shall be done departmentally by this office. In view of the above, the work order and agreement dated so-and-so signed with
What
this
about,
office.
there was no notice?
No notice, my lord, no justifiable reason for this.
Instruction, my lord.
Yes. Dr. N. Muzika, Learned Counsel, Senior Counsel, with MS M. Rityang, Mr. Arkhas are present, except on behalf of all the respondent referendums called for. Stop. The grievance of the writ petitioner is that an agreement dated 12/5/2023, wherein the writ petitioner was where is that?
Para 2, my lord.
Yes.
It's a preparation and printing of digital smart card based
for the work of, where's that print? Where's it written?
Page 15 was subject, your lordship may say. Preparation and printing of digital smart card based.
The work of preparation and printing of digital smart card based sticker computer cheating license has been cancelled without notice by the impugned letter dated 4/6/2025. Submitted by the Senior Counsel that the term of the agreement for printing these smart cards was for 5 years, and as such the action of the respondent without notice and cancelling is arbitrary. So Mr. Arkhas, please be allowed to obtain instructions.
Yes.
So accordingly, this is matter after 2 weeks.
2 weeks.
2 weeks. In the meantime, the impugned letter shall not be given effect to. Yes. Just accordingly also.
I'm deep.
Obliged.
Implement letter date 4/6/2025. Not be given effect.
Item number 6.
Yes. Where's the respondent? See, the thing is that this matter was heard. Right? It's just for judgment. Now, on that time when it was heard, we was heard extensively on maintainability and also on merits. Both sides have placed the merits. Only one thing, Mr. Nongri, we have not heard you. I think on merits. You have anything to say on merits? You have anything to say on merits of the matter?
Yes, ma'am.
What do you have to say? Can you complete the arguments now?
On merits, ma'am?
On merits? Merit, because you just Shillong. What is that? Come to the side, please. Yes. Shillong Golf Association.
Yes, ma'am.
So you're just a beneficiary of the affiliation that's been given to you.
Yes,
Do you have
ma'am.
anything to say on merits? Because the court had, on 2 counts. That is, whether it's a public action of the Indian Golf Union for this affiliation, and secondly, whether this matter is amenable to writ jurisdiction.
Correct.
So on those 2 grounds, we had heard extensively senior counsel, both senior counsels. Only thing is that whether anyone has anything else to say on the question of on the merits of maintainability, because I think we'll decide together maintainability and merits.
My lord.
So you have anything else to say, or we can close it for judgment?
My lord, may I have it tomorrow or?
I would tomorrow will hear you. I don't
Yes,
think Mr. Paul has
Lordships.
anything more to say.
Lordships may have it tomorrow or day after,
Have it
Lordships.
tomorrow, because we'll close it, because this matter has been just hanging in my docket, and actually it is already heard. Mr. Changriso has been heard
In fact, I
extensively, and he has given his bullet points on maintainability and on merits also.
on merits. In fact, I'm yet to touch, but my lord,
You already argued on merits, Mr. Changriso.
on the maintainability, my lord, I filed the affidavit in address. But on merits also, my
But I don't want to extend the arguments. Only I can give only one day. I can fix one day, tomorrow, day after. We'll hear it out and we'll pass judgment
Lordships.
immediately thereafter.
Because even on merits, my lord, it is learned senior who will
Merits,
has to
we already heard on
defend.
merits. Mr. Changriso already argued
short address, my lord.
for half a day on merits that day. So, yes,
Tomorrow, my lord.
tomorrow.
Lordships.
So we won't leave it, yes.
Obliged, Lordship.
Yes, so the parties list the matter tomorrow for the final hearing is.
7.
Thought me as some point in some clarification. The parties agree that the matter will sit tomorrow for final hearing. Yes. Yeah.
Please, Lordship. Notice has gone to the private respondent number 6.
You are appearing? The Nongpur?
No. For
It's
1
for
to 5.
disclose.
Yes, officer indicates that copy of this court's order dated 2/6/2025 has since been forwarded to respondent number 6. Less than 2 weeks to await any outcome here. Yes.
8.
Yes.
Lordship, earlier in this matter, Lordship, notice has already been issued, Lordship. But Lordship, due to some lapses, Lordship, we could not take steps upon respondent number 1, 2 and 9, Lordship. We went to the registry, but registry is asking for a fresh order, Lordship. Hence, Lordship may kindly give us liberty to take steps upon 1,
This
2
is not
and 9.
maintainable. Mr. What's your name? Saikia.
Yes, no notice has, I don't think, my lord, notice has been issued in this matter.
Notice has been issued, Lordship, 6th of June, Lordship.
Only for maintainability, matter was kept for hearing.
Where's Dr. Saraf? He's not available today.
No, Your Lordship. We have to complete the steps. For today, Your Lordship may kindly grant us liberty to take
Okay,
steps
Mr.
on 1, 2 and
Saikia.
1,
Your
2 and
name,
yes,
Mr. S.G.
S.G.
Saikia. Yes,
Yes,
today prays that we be allowed to take steps on response number
1, 2 and 9.
1, 2 and 9. Prayers allowed. Steps will be taken within 2 days. Just after 1 week. Yes.
Highly request.
Item number 9.
But please, Your Lordship. Lordship, we have filed a miscase.
Why you filed a miscase?
My Lord, during the pendency of the matter, my Lord, An impugn order was passed by the Deputy CM, my lord. If lordship comes to page 11, my lord. 30/5/2025.
Of the
Lordship,
miscase.
of the miscase, my lord. Annexure 2.
Page?
Page 11, my lord.
Okay. Yes.
So, we being aggrieved by this order, my lord, we are before this honorable court. Because the Deputy CM has no jurisdiction to pass this order, my lord.
No, what happened? What happened is that
Lordship, what has happened, my lord? They have filed a writ petition, my lord. 152 of 2025. My lord?
why you got the bamboo for sale? There's a prohibitory order against extraction of any forest produce.
No, my lord. This is a Mahari Reserve Forest, my lord.
Okay.
So, this order was passed, my lord, without impleading me as a party. And moreover, the matter was already taken cognizance by the CEM, my lord. By order dated 7/9 of 2019, my lord, by this honorable court. So, thereafter, my lord, when the matter was still pending before CEM, and the CEM has passed an order, my lord, condoning the delay of 442, my lord. Being aggrieved by that order, my lord, they are before this honorable court. And after they have filed this writ petition, my lord, taking the advantage of that writ petition, my lord, they have started felling the bamboos, my lord, and started transporting huge numbers of bamboos, my lord. So,
what was brought into before
so
us, my lord?
let me just complete. So, what happened, my lord? So, the reserve forest ranger, my lord, they have seized the bamboo. Thereafter, they have obtained an illegal order from the Deputy CM without impleading me as a party, knowing very well that the matter is pending adjudication before this honorable court. Thereafter, we have brought to the notice of the CM, but the records are before this honorable court, my lord. So that is why, having no other alternative, my lord, we are before this honorable court.
If my lord may kindly peruse the order. The order said, whereas an application has been received from so and so,
yes,
the registered Nokma of so and so, on behalf of Rangsa Mahari, seeking permission for transit of bamboo,
yes,
sold by the Mahari from the Mahari Reserve Forest under so and so Aking, and whereas it has been stated that the same Mahari Reserve Forest is not under the jurisdiction of the Forest Department of JGDC, nor clarifies as the Council Forest. Yes, well, here, my lord, we have passed this order because that from the forest which they have, my lord, taken out the bamboos, my lord, is not a district council forest, my lord. That is what we have just clarified. Now, if they have been impleaded or not, my lord, it is for the parties, my lord, to implead or not to implead, my lord.
No, but permission granted, see, last paragraph, permission granted purely in his customary rights of Mahari over the said reserve.
Yes, my lord. The permission is granted purely in reconsideration of the customary right of the Mahari over the said reserve and shall not be considered as a precedent for the sale or extraction for notification of council forest under the GHDC. Only, my lord, we have said, my lord, that it is not a district council land, my lord, or district council forest, my lord.
Be that as may, my lord, the matter is pending adjudication before this honorable court, my lord.
That is regarding the Aking, my lord.
The Aking, that is what that is. The bamboos are within the Aking, my lord. That dispute has not been adjudicated. It's still pending, my lord. So I'm just praying at this moment, my lord, that let it be stayed, my lord. Because by taking advantage of this order, my lord, they're trying to clear off the entire bamboos, my lord.
1 second. Yes, why are you felling the bamboo?
No, Lordship, may I submit? This miscase has no relevance with the present case which is pending. The WPC 152 is regarding the condemnation of delay and regarding the Aking matter. Here they have filed, there is a separate subject matter. The
No,
case
in the
which is
main
pending
petition,
before
is there any interim order with regard to extracting or felling any trees and them or nothing?
No.
Then?
That is
no,
what, madam.
They have filed they have filed a writ petition, my lord.
Let me complete. If there is agreement, this is the order of the CEM. That means IC Land and Revenue. If there are agreed, still there is affiliate authority.
The case record are before this honorable court, my lord.
Doesn't matter.
No, we have already, my lord.
My lord, may I kindly see the writ petition copy, my lord? That is page 56, my lord.
There is nothing. No.
Just a minute, please.
Yes.
My lord, may I kindly see peruse the second last and last paragraph, my lord.
Yes.
explain the legislation. And considering the fact and circumstances of the delay of so and so is hereby condoned, giving an opportunity to the parties to argue the matter on merits in the interest of justice, my lord. Now, my lord, delay was condoned, my lord. And against that, Mr. P.T. Sama's client is before this honorable court by way of this writ petition, my lord.
Yeah.
Now, wrongly, rightly, my lord, the petitioner, my lord, who has approached this honorable court, my lord, they are the NOCMA, my lord. That order has not been set aside by the CEM, my lord. My lord may kindly appreciate. It is in the acking belongs to the petitioner, my lord. Now, my lord, the respondent, until unless he prove, my lord, that he owns the acking or he is the acking NOCMA, my lord, how he can be aggrieved, my lord? Yes, and there is no stay.
You take it before the CM.
We have, my lord. But the case record are before this honorable court, my lord. So the CM cannot pass any order, my lord.
Regarding on the bamboo only.
Yes, my lord.
This case record has no relevance.
So by taking advantage of this order, my felling of the entire bamboos, my lord, reserve forest.
See, Mr. Bhumi is still on the outside looking in, correct? They are in possession of the acking, correct?
Yes, exactly.
No, it's not. No, my lord. We are in possession, my lord.
No, position maybe you are, but not the NOCMA of the acking.
That matter has to be adjudicated, my lord. That is pending before the deputy CEM or pending before the CEM, my lord.
The thing is that coming back to the basics is that there's a condemnation of 3,442 years, whatever.
Yes.
It's more than 10 years, correct?
Lordship.
10 years. Now, naturally, they'll be aggrieved with the condemnation given because that they'll again, question their rights.
Lordship.
So that's the thing. Now, this one's independent of, that your dispute that you have with regard to. Now, as it is, he's still from, like I'm saying, outside looking in. So they are controlling the acking right now. So any orders you pass, you get it from CEM. This has no bearing with the form. You can.
No,
you
but
can
the
file
difficulty, my
also.
lord,
You go. We'll give you liberty. You take copy repetition and say this is the matter pending. It's come 3-4 times before the High Court. Directed again. Now you've condoned a delay. Now after condoning delay in my favor, see what they're doing. You go there.
We have already approached, my lord. But the difficulty is, my lord. But the difficulty is by the case recorder before this honorable court, my lord.
Case record has no relevance.
Case record with the acking dispute. Yes. Now you take the copy petition and show them. Because
if lordship passes an order, my lord, direction, then we have no.
This case 130/2025 in WPC 152/2025 by the instant Mrs. application filed in the connected. But sorry, the respondent's number. What in the petition?
4 and 5, my lord.
In the 4 and 5.
Yes.
WPC 152 of 2025 as applicants are before this court assailing an order dated 30/5/2025, order number 62 stroke GHADC stroke Land and Revenue stroke 2025 dated 30/5/2025 passed by the Deputy Chief Executive Member, whereby permission is granted to remove some quantity of bamboo felled by the Maharis of Watso Akeng. Stop. As the same may be damaged if not transported. Yes, urgently. Stop. Next number, AG Movement submits that in spite of the pendency of the matter before this court, the respondents are seeking to, what do you call it, extract?
Yes, my lord. Transport, my lord.
Transport the bamboo. So he prays that the order allowing the same be interfered with. Stop. That is next paragraph. Mr. SD, Council, Standing Council, OGC, and Mr. P.T. Sama have voiced objection and submitted that the purported legal action or the felling bamboo is done by the recognized NOCMA, that is the respondent in the petition, and there's no illegality involved. And further, the forests not being under the jurisdiction of the Forest Department or a council forest or a Mari forest, such permission was granted. Stop. The further submitted that this case is incompetent, as the petitioner should approach the Chief Executive Member. Today, Mr. Ejivan submits that as the records are pending for this court, the CM is not in a position to pass any effective orders.
Yes, ma'am.
Heard and council parties, it is noted that it is correct that the order has been passed by Deputy CM. Any relief that the petitioner claims can be sought before the CM. He permitted to place a copy of the petitioner with orders for adjudication the same. This case stands disposed of.
Highly obliged, my lord.
10. Item number 10.
You can send an inquiry also if you want. Yes.
Highly obliged.
Item 10 and 11 are relating to boundary dispute, my lord. Matter is pending before the Honorable Supreme Court.
Yes. After 6 weeks, yes. I same order. The matter is pending soon.
12.
Lord, the connecting appeals are coming tomorrow, my lord, before the division bench, my lord. With regards to the contempt. So I'm praying.
Of tomorrow itself.
Lordship, I am praying that it come after a week, lordship.
12, 13, 14.
It will be over by a week. Yes, after 2 weeks.
13.
12, 13, 14.
12, 13, 14.
15.
15 and 16 are connected, my lord. And we have received the instruction, my lord. I'm praying for 2 weeks' time for affidavit.
What's the matter about Mr. Bora?
Service matter, my lord.
Mr. Counsel? Oh, sorry, no. Yes, as prayed for the 2 weeks' time out for affidavit. Yes, after and so on.
16.
Connected.
17.
Item 17 and 31 are connected, my lord. Regarding MT80 qualification.
13 and
17 and 18, 31 and 32, your lordship.
17, 18, 31,
32, your lordship.
Lordship, we have filed a service affidavit, lordship, in this item 17 and 16, lordship.
Who's number 7? Who's for number 7? You are. That is WPC number 444. Then in 444, who's this one number 7?
NCTE, lordship. The report is showing that it has already been delivered.
Who's this for number 7?
NCTE, lordship.
National Council for Teacher Education, your lordship.
All the other responses have been served.
Yes, lordship.
No. Yes. An affidavit of indicating service upon respondent 7 has been filed with petitioner, showing that notice was received on 2/6/2025. So accordingly, the notice is complete on behalf of all the respondents. So, yes, what do you want now?
I should let them file affidavit, lordship.
What affidavit? Yes, Shulai.
Lordship, in fact, your lordship, 17, 18, your lordship, in my respectful submission, your lordship, these are become infractions, your lordship, because the main petition is that is the item 31, your lordship, 405 of 23, your lordship. Because in this your lordship, appointment had already been issued, your lordship, and those private respondents also have been implemented as party respondent.
Here, lordship, there's this respondent
now
number
you see
8.
444 yes. And 445 infractuous.
Lordship, yes.
Yes. Yes.
Lordship,
let them file affidavit, lordship.
If lordship, can you have 444, your lordship, the prayer made in the writ petition?
Yes.
Then take out that.
Because here the respondent.
MT80 certificate.
405.
To set aside MP notice 1.
Then lordship, if lordship, can we have a writ petition number?
1 second, Mr. Shulai. Now set aside appointment orders of the private respondents 8 to 15. What is private respondents?
Here, Lordship, are challenging their DLS certificate, Lordship. DL at 18 months.
444. Who's appearing? Then you said notices served on all the respondents?
But we've already served, Lordship. We've already served. The private respondents.
My lord, but the legal issue is common, my lord, that 18 months MT80 certificate.
18 months DL
Now 18 months has been, Supreme Court has said as perfectly all right.
Lordship, that one.
In number of
as far-
judgments, my lord. There are about 10
My
orders passed by
instructions,
Supreme
Lordship.
Court of Meghalaya.
I'm appearing for item 32.
No, the next 445. 445. Lordship, kindly have writ petition 444, your Lordship. Kindly come.
See, 8 to 17 have not been served.
Also, we have 8 to 17 we have served. We have already
You
served.
didn't file, you filed service affidavit.
Which I suppose we have already filed, Lordship.
No.
Yes, Lordship, we have already filed service affidavit.
27.3. Yes, Mr. Shulai.
If Lordship kindly come to writ petition 444, your Lordship, kindly come to page 20, your Lordship. That is the really short in the writ petition, your Lordship.
Yeah.
Lordship, kindly see, your Lordship. Set aside impugn notice, dated so and so, notice so and so, an appointment so and so, your Lordship. Then, Lordship, kindly come today at page 18 to of writ petition 445, your Lordship. It's same, your Lordship. It's almost same, your Lordship. Then, Lordship will kindly.
Yes.
Then, Lordship, kindly come to writ petition number 445, your Lord, 405, your Lordship.
Lordship, in 445, Lordship, we are challenging the fake certificate which was issued by the
Lordship,
Assam.
this is Lordship. They have challenged
Therefore,
that
we have
18 months, your Lordship.
needed
18 months.
State of Assam.
Diploma, your Lordship.
1 second. 1 second. Where's the prayer?
The prayer, Lordship, in the writ petition almost same, your Lordship.
Page 23.
Give me.
Okay, 18 months only.
Lordship, yes. Then, Lordship, in view of the decision rendered by the Honorable Supreme Court in Bishwanath, your Lordship.
Yes.
So, your Lordship,
No, that's all
this
I know,
matter
but,
will become in
what was,
process. All
Mr.
will
Takhal
become
saying
in
about
process.
fake
Lord.
certificate?
That is with regards to 445, Lordship. Yes. The certificate which was issued by the state of Assam.
But the thing, the prayer is identical to 444.
But 3 writ petitions are there.
No,
one issue.
Mr. Charyeso, in 444, you've challenged the 18 months, correct?
18 months, one. Second
Yes,
is.
Now 444 is 18 months, so that will go in fructuous because of the Supreme Court says 18 months is fine. Now 445, you say, you just see the prayer, you challenge the.
Yes, the fake certificates. And the third one is, my lord, with regard to the OPC. My lord.
1 second.
Lordship, if I clarify, my lord, because the first lead matter is 405, my lord, item 31.
One second, let's just clarify this prayer is identical, but then
in the other matter, my lord, what my friend
no,
is saying that the
one second, Mr.
certificate issued by
Charyeso.
state of Assam is fake. My lord.
Yes. So
Slightly different.
place
Slightly
forward.
different.
Yes. So you're saying that the 2-year certificates given by the private respondents in WPC 445 are fake?
Yes, fake. RTA reply.
444 no. 444 we can close it.
My lord, this is a lead case, my lord. I would satisfy, my lord.
For it has no relevance now because 18 months is fine.
My lord, may I just surprised regarding this one. When the selection took place, my lord, the Supreme Court held that 18 months is invalid, illegal. Then thereafter, my lord, selection completed. And after completion of selection, they issue appointment letter. Subsequently, the Supreme Court passed an order that the 18 months is valid. That Supreme Court order is not retrospective. It is all prospective only. With regard to that note, I'll clarify, my lord. For that purpose, my lord, the lead case is still relevant.
Supreme Court, my lord, has clarified clearly that the 18 months diploma is valid right from very beginning, my lord.
It didn't say.
And
It didn't say
got
that.
not one. There are 7-8 orders passed by the Supreme Court time to time. And even the earlier order of the Supreme Court clearly covered my case that 18 months diploma is valid diploma, my lord.
We would satisfy, my lord, with regard to that aspect.
The judgment says now the judgment says this. Are you referring to this Vishwanath and others?
Vishwanath, your lordship.
Order dated
that is the order dated
10 December.
Just a minute, lordship.
24.
This is 10 December, your lordship, yes.
But it says, see, come to para 2.
Lordship, yes, we have
employed as on 10/8/2017. Maybe what senior counsel is saying has something. We are therefore not inclined to retain present restrictions. As, however, to avoid any confusion, we again clarify that the 18-month diploma obtained by such persons who are in employment as on 10/8/2017 and who have completed diploma course of 18 months would be treated as valid diploma holders for the purpose of applying the institutions
or for promotional avenues.
Needless to state, clarification effective from the date of pronouncement of the judgment of review. Even then, that is confusing. Yes, what do you want to say?
Please, may I pray? If Lordship pass the matter for admission hearing.
Yes, sir. Yes, sir.
Yeah, my lord, I clarify, my lord, what has happened, my lord, that in the initial judgment, the diploma which was given in all these cases are obtained by the persons who are in government services or services in the private school, my lord. So that 18 months diploma for those who are in service, either in the government or in private, has been held to be valid, my lord. Those, and there are series, in fact, my lord, I can give compilation, my lord. After Vishwanath Chaudhary also, there is an order passed by the Justice Gawai also, my lord. And that order is also, I can, your lordship may keep it for final hearing. And I will supply the entire set of the orders passed by the Honorable Supreme Court. Even on 4th April 2025, the order has been passed in the case of, my lord, by the Honorable Supreme Court. So I will place the entire compilation. Lordship may have it after 1 week.
For admission hearing, if Lordship, subject to Lordship convenience, for admission hearing, my lord. And dispose of, in that. Yes.
Kaushik Das, my lord, the name of the
okay,
matter
if
is
you bring whatever it is,
because
we need some clarification also. Yes, on the request of the parties, let these connected petition, that is WC number 405/23, then
405, your lordship.
It's the lead matter, my lord.
Item 31, your lordship.
Then 32 is WC number.
Then another lordship, WPC 66 of 24, your lordship. Item 32.
Then 444.
Then lordship, item WPC 444 24
and WPC number 445.
445, your lordship, 24.
Yes, for admission hearing after 1 week. Now, first an item. That is item 445. 445 also should.
And the item, lead item should be, my lord, 405.
405, your lordship.
405. The counter
Yeah,
affidavit has already
here,
been filed in 405.
now in 445 for actual service upon indicating service upon respondent 456 has been filed by the petitioner. CMT on record So all responses served in 445. Such all responses served 445, yes. Are you appearing for private respondents anyway? Which matter?
18, item 18, 445.
Okay.
18 in other. 18,
Yes.
31 and 32 all are represented also.
Jim. Four. But you kindly make a compilation of the orders, then we'll examine them.
Yes, I'll place, Milord, I have those orders with me.
Yes.
All right, Your Lordship.
19.
May I please, Your Lordship? Your Lordship, pleadings are complete, Your Lordship. Your Lordship.
You want to rejoinder?
No, Your Lordship. Your Lordship, may I fix this matter for hearing, my Lord?
My Lord, for respondents 6 and 7, matters gone ex parte. Seeking Lordship's permission to file a miscase to vacate that ex parte order, my Lord.
If you file it, doesn't matter. We'll see whether we allow it or not.
But the registry may require Lordship's
yes, Mr. S.K. Hassan submits that the matter is ready for hearing. Stop. However, Mr. S. Jindal, who was the counsel, or who was the counsel for response 6 and 7, against whom the matter has gone ex parte, prays that may be allowed to file an application for recall of order dated
19.5, my Lord.
19.5.
25. 1952.
Prayer allowed, yes. Just after 1 week.
20.
May it please your Lordship. Lordship, in this matter, I prayed for 2 weeks' time to file the rejoinder of
How
affidavit.
many times you prayed?
Second time, your Lordship.
Yes, for a 2 weeks time as prayed.
Apply, Your Lordship.
Allowed for rejoinder.
21.
Yes.
For the appointment of arbitrator. Look at my specs.
I'm praying for a week's time.
Instructions?
A week's time.
When was the contract over?
2022, 23.
Dr. Muska, please follow.
My Lord, let it come on Friday, my Lord, 27th. 27th.
Okay, on Friday 27th.
22.
I'll be filing my rejoinder in the course of the day, Your Lordship. That matter come up for hearing.
This is what?
This is regarding
Collision matter.
regularization.
Regularization, Your Lordship. They are asking for from the time they were ad hoc appointees.
How much time?
I'll file in the course of the day, Your Lordship.
Praise that the rejoinder file in the course of the day. This is a matter for hearing.
Right, Your Lordship.
Thereafter.
23.
Also.
May I please, Lordship? I am yet to receive my status report, Lordship. I pray 2 weeks time to file affidavit of service.
Lordship, I'm praying for 2 weeks' time to file my affidavit, Your Lordship.
Number 5, you've taken steps.
Yes, Lordship, I have taken steps.
Mr. Amarak prays that we allowed 1 week's time to obtain. Just you file affidavit.
I need some more time, Your Lordship. 2 weeks.
How much?
2 weeks, Your Lordship.
Mr. Pala for respondent for praise for further 2 weeks time for affidavit praise allowed less after 2 weeks. Yes.
Much obliged.
24.
Lordship, it's for appearance of respondent number 3. UGC, Your Lord.
UGC?
UGC. You have filed affidavit.
How come no one's appearing last? She appeared in the first date. What about number 4? Number 4?
Number 4 also we have served.
You served?
Yes.
But you filed service affidavit then?
Affidavit 16 June 2026.
You filed affidavit?
2025. Yes.
You filed service
Yes.
affidavit?
Yes. 16 June.
Oh yes. What to Mr. Debnant?
Lordship, here Union Field is not the is only former party, Lordship, because
Exactly. You inform her you personally from your own. MSP Agarwal is not present on behalf of number 3, and on behalf of number 4, the notices have been served, none appears. This after
2
1
weeks.
week, yes, for further orders.
Yes. Obliged.
25.
Definitely, Your Lordship.
Yes.
Lordship, for the petitioner, Lordship, they are yet to file their affidavit.
Yes. No, they have you issued notice to
Yes, Your Lordship.
to this yeah? What's this
Yes, sir.
Eastern Coalfields?
Yes, sir.
Not to Coal India.
2, 3, and 4, Your Lordship.
Yes, Mr. Saikia admits that status of service not received with regard to no, so office report indicates that service for one only. One you are. Yes. So office indicates that service not complete on behalf of respondents 2, 3, and 4. Published after 2 weeks to await.
Lordship, there's an
service
interim
report.
order.
Yes. There's
Interim
an
order.
interim order.
Interim
We
order.
shall continue it. You check the status. Yes.
Okay.
26.
Fire does matter. Yes.
Malan. I just asked Lordship to have a look at the last affidavit that we had filed, ignoring all the voluminous record, my Lord.
Last affidavit.
It's filed on May. Date of filing. Filed on 27th of May, my Lord. 7th of May.
2025.
2025, my Lord. From page 10, my Lord, is the judgment against which, my Lord, we had come.
1 second. 747.
Because if we open the contempt petition, it becomes bulky.
I'm going to affidavit and then. Yes, this is additional affidavit.
My Lord,
Yes.
just to sum up the matter, my Lord, because
Filed by the respondents.
it is filed by the contenders, my Lord. Oh, sorry, the petitioners.
27.5.
27.5, my Lord. I just given two documents there. These documents are already part of the record, just to make it easier, my Lord, to peruse.
Mm.
The judgment, my Lord, knows very well that when the Fifth Pay Commission came, my Lord, a structure was made that you have to be given the rank and pay according to class. Class 3 is Havaldar, Class 2 is Warrant Officer, Class 1 is Naib Subedar. So, in case of other trades, my Lord, they have implemented it, my Lord, by giving the persons who have done Class 2 to be a warrant officer. That is the case of the ciphers, though the actual benefit is yet to come also for the ciphers. That would be Mr. Paul's case. My case is that, my Lord, we were given Havaldar. it is a different thing that we were not given warrant officer. That might probably give rise to a fresh cause of action, my lord. So we probably will not be in a position to hesitate the same in a contempt petition. But then as far as the Havaldar is also concerned, my lord, lordship would look at page 15. This is how, my lord, the order was to be passed. Towards the bottom, our case was preceded already by another matter, that is Writ Appeal 50 of 2010. Towards the bottom, if your lordship reads the last sixth line, against the judgment and order of the division bench dated 22/9/2011, the respondents filed SLP before the apex court, which was dismissed, filed order dated 2/7/2012. After dismissal of the special leave application, respondents had complied with the directions of the division bench of the Guwahati High Court dated 22/9/2011, passed in WA 50/2010 by passing an order which is Annexure 12 to the writ petition, which is quoted as under. Now this order, lordship, is very important. This is how the compliance came. It says, my lord, the underline in the first para has been redesignated / upgraded to Havaldar, ORL.
Yes.
So this was what, in terms of the earlier division bench order and apex court order, my lord, this was the compliance that was made.
Yes.
And in para 7, therefore, in our matter, the learned judges say that in the above factual backdrop, that you had already made a compliance of orders in terms of redesignating and upgrading people. It says that in terms of Writ Appeal 50 of 2010, it shall squarely cover the case of the petitioners, and accordingly respondents are directed to give the benefits of the judgment and order of the division bench of the Guwahati High Court dated 22/9/2011 to the writ petitioners. So our case, my lord, at least if not considered for, my lord, warrant officer, there is a clear directive that this is the order that you had complied with earlier. So now also you have to do, what you have to do is to redesignate and upgrade us. In fact, my lord, if lordship perishes page 18, initially, my lord, when the writ appeal and the SLP was pending, arising out of our case, on 23rd October 2015, the Ministry of Home says that you are upgraded and redesignated. Then, my lord, before this order is complied, the mischief is played in page 19, my lord, which is again an order now issued by the colonel personnel only of the Assam Rifles without consultation with the ministry, because there is no reflection that it is as per ministry's directive. They changed the order now, my lord, to upgradation / promotion.
Yes.
So therefore, my lord, this change in view of the express quoting of this earlier order at page 16, that this is how you had complied earlier and therefore you extend the same benefit. So instead of giving us the same benefit, this modification, my lord, would not have been done, my lord. So therefore, my lord, I had placed the judgment on the earlier occasion that in such cases, my lord, even though it's a contempt jurisdiction, where such apparent playing around with the order of the court has been done, my lord, in such cases, my lord, a further opportunity or a direction can be passed, my lord. In fact, prior to
hold this Sarav Charan, Lieutenant Colonel, as must be retired by now.
My lord, the new parties have been implemented, my lord.
No. See, the author of the contempt does not lapse with the thing. You can just add parties.
My lord,
you can't subtract them.
Like my lord, he signed for DZ Assam Rifles. He signed for DZ Assam Rifles. So DZ is a party, my lord. So DZ is a party. Even a new DZ has been implemented, my lord.
But there have been n number of judgments whereby this upgradation promotion has been thrashed. So,
my lord,
if it's still not done, what is the problem? That's why we don't understand.
My lord, the better sense should have prevailed, my lord. In fact, I'll just simply place, my lord, earlier in also 2015, a similar occasion came before the Supreme Court. And though I had placed the 2023 judgment of Justice Pardiwala, In this case also, my lord, it says that if we ask the respondents to correct the order, it does not amount to a further direction, because if there is an express direction earlier in the order, it does not amount to a fresh direction in a contempt. It only amounts to reiterating what my lord has already been held. And as far as this part is concerned, my lord, as to redesignation and upgradation, a clear quoting of that particular thing is there in the learned single judge's order. So that cannot be now modified, my lord, by saying that it is not upgradation, it is promotion, my lord. We were to be squarely covered by this order only, my lord. Warrant officer part I am giving up, my lord. That of course, my lord, it's a higher rank, we might have to hesitate in a different direction.
There, yeah, warrant officer also, because one single bench of this court so allowed that. That's an appeal, correct?
That's a different treatment. This is
no, this is the Prem Singh, same thing.
Electrician.
Yes, electrician. Prem Singh, correct. Instead of Havaldar clerk, they gave straight one officer is allowed.
It's pending for the DB.
In Mr. Paul's case, I think
my only submission,
in Mr. Paul's case, he doesn't have. The thing is that his traits covered squarely, so there can be no excuse of not complying with whatever.
But our case is valid as far as cyber is fully.
Contempt, who is going to fix now? Contempt, who is going to pull up here before the court issue contempt proceedings? And
but the difficulty
we reach a stage where yes, we are total agreement that the judgment of 1000 and whatever 15 has reaffirmed the directions given the earlier judgments that for other trades that you have to upgradation and on a basis of that. But that corrigendum has changed everything.
Because it's redesignation becomes upgradation. That's where the.
My lord, my only submission, my lord. This contempt, my lord. I'll confine my submission to this contempt, my lord.
Fine to the contempt, but
this is pending since.
It's very easy to say that in contempt eviction, this court cannot pass directions.
Not only that,
we can pass directions, and we are bound that way to see whether, on the face of the record, there's been some willful violation of the orders. So to reach that, whether willful violation or misunderstanding, we don't know. But the thing is that to again, compel them to go through the entire, like they say, walk of the gauntlet, of litigation, right from the single bench again up to. That might dilute the whole thing. What they've already achieved in that 2015 order.
But it's not that. I'll just make two or 3 points, my lord. But this contempt is pending since 2015, my lord.
Yes.
And Union Home Secretary and Director General of Assam Rifle are the respondents, my lord. Over a period of 10 years now, my lord, I believe 5 to 6 Union Home Secretaries have changed, my lord, and 5 to 6 or maybe even more Director Generals of Assam Rifles have changed, my lord. Now to fix a responsibility upon any one of them, my lord.
Yes.
Because lords submitted, they cannot be subtracted, they can only be kept on aiding, my lord. So there must be 10, 12, 14 respondents by now in the contempt, my lord. That's my first aspect, my lord. Second submission, my lord.
Yes.
That very recently, my lord, in the year 2025, your lordships have passed order. The Malaysian authority is there. I'll place that. I'll just have print out, my lord.
Yeah.
Some of the petitioners who are situated like them, my lord, they came by way of fresh writ petition before this honorable court. Your lordships were directed, my lord.
And they've been complied.
It has not been complied with, my lord. This is in the process of compliance, my lord. And we do not know whether department will file an appeal against that or challenge that or not. But that is my submission, my lord. This is not a matter of contempt anymore, my lord. This is a matter which requires a fresh adjudication. Some of the petitioners have already approached this honorable court, my lord. I'll place that order. My lord.
You give the petitions. Otherwise, then that'll cloud whole issue.
My lord.
Otherwise, if you read it very plainly,
my lord,
there's nothing to decide.
So, my lord, so what?
It's really a fixed responsibility.
So, my lord, the adjudication in those which came in 2025, my lord. So, in my humble submission, the things have been clarified only in 2025, my lord. So, there is no question of being any willful disobedience of any order in the 2015, my lord, when the order was passed.
Well, in our case, my lord, 2012 itself, order was passed. It is redesignation and upgradation, and we were also directed to be given the similar benefits. Instead of that, my lord, how can it be modified, my lord? And lapse of time, my lord, will not dilute the contempt. And the punishment is not the objective, my lord. Majesty of the court is, my lord, is more
Is it correct that
important.
some of these petitioners themselves have gone independent writ petitions?
That I
My
have
lord,
to tell.
my lord, they are the writ petitions in the same writ petition, my lord. They have come separately.
No, that is what.
That I have to tell you, my lord, from the list.
You supply the details,
My
and
lord.
we'll work out a way. Otherwise, from what we can see, this court is not inclined to to prolong this. And whatever orders have to fall under 215, whatever.
But some of their own petitioners have followed that route, my lord.
Maybe
They should
we'll
also follow
hold
the same route.
contempt, but we'll direct that they should be complied with, my lord. Whatever be, and those other petitions.
Like
take
Gauri
the
Prasad's
course.
case, my lord, the apex court had taken a similar view.
And my lord,
We
will
are
see-
not passing a fresh order. We are only reiterating that what
My
was
lord, we
there
see-
expressly earlier.
We will give latitude that
My lord,
due to the lapse of time and maybe misunderstanding or misinterpretation of the orders, whatever happens. But if you reinterpret the order that has been passed 2012, 2015, there's no scope for any, confusion.
My lord, one more aspect, and that will have serious effect. My lord, there are 2,200 odd petitioners in the original writ petition. My lord, that is WPC number 56. On contempt petition, there are only 12 of them, my lord.
112 of them.
Only 12 of them, my lord.
Still, my lord, it's
And
a
out of those
even if one is
2,000
there,
to
my lord,
100
it's a
something, my lord, they have taken a different route. They have filed a writ petition before this honorable court, and your lordship passed certain directions, and those are under examination now, my lord. So, my lord, in my humble,
Even those orders that are passed regarding that upgradation and promotion, they still not been implemented till now. Does Asim Roy, whatever?
No, my lord.
Because
well, Asim Roy is a different trade, my
well,
lord.
it
Asim
will
Roy,
ultimately be the same.
Asim Roy is cipher,
First
my
single
lord.
judge, my lords, then division bench, then Supreme Court. Once you get, my lords, fired from the Supreme Court, you will come back, you will interpret the order in your own fashion, say that we've implemented
But contempt is not a
and
short
then
short
come
circuit
back
for that,
here,
my
my
lord.
lords, and say that, okay, let them come by way of a fresh writ petition.
Well, short circuit.
It's a never-ending cycle. So
Well,
what I
contempt-
also say, my lords, just taking a cue for what my friend is saying, it's not only willfully, my lords, not compliance, willful non-compliance. Subversion is also a contempt. If I know what is the purport of that order, my lords, and I subvert it to my convenience, that would also be contempt. So this may not
but
be.
Then the thing is that who will figure responsibility on the current Home Secretary?
Well, it is a continuing cause of action. If there is a mistake committed or an error or a default committed by an officer X, I subsequently come into the chair. And if I do not rectify it, I am equally responsible for it. So that will not hold water. That 15
play some
people have
decision
gone.
on that, my lord. If there are 5 contemners over a period of 10 years, who will be actually responsible?
Well, every day would be a continuing cause of action. If an order of a court is not complied,
We
every
have
day is
to
a
catch
continuing cause of action.
DG at the relevant point of time. Whatever, what his name was. What is the DG at that time?
2000.
23rd August 2016.
Was R.K.
Goel.
No, Goel was Home Secretary, my lord. R.K. Rana was the Lieutenant General.
Who was DG?
R.K. Rana, Lieutenant General R.K. Rana. my lord.
Shocking.
Where is he now?
He must have superintendent a long time back, my lord. Where the Lieutenant Colonel on the verge of retirement as it is, my lord.
No, this is Saurav Charan.
Saurav Charan is a colonel, my lord.
आपका कौन सा 2015 में है ना? Yours is 2015.
2015.
Yes.
We can find out, my lords, who was the relevant DG at that point of time.
I
and
know,
Home Secretary.
see, contempt is 2 stages. One is taking cognizance that the contempt is made out. Then the whole process starts under the High Court rules and under the Contempt of Court Act. Then we have to give them a show cause again.
Now to whom? That is a question. Again, to whom, my lord? That.
No, that's why we're trying to see who was at
So
point of
10 or
time.
12 of them, my lord.
If I may.
Many of them, some of them are governors.
No, will not drop contempt against.
Notice of contempt.
Some of them are governors.
Notice contempt will go to the DGR who was there at that point of time. Someone had,
some fixation of responsibility.
Lordship will enter into that exercise if there is a clear case. My lord, I have not seen any contempt application, my lord, which has to be argued for 10 years, my lord. The fact that they have to argue so much, my lord, that itself shows there is no contempt, my lord.
Then you go and appeal. Will issue notice of contempt.
No, there is some substance, my lord. That is why we have been deliberating on
I'm
it
so sorry to
for
say,
years, my lord.
In a similar matter, my lords, the Honorable High Court of Kerala had directed one appearance, my lords, and before the date of appearance, the order was complied and the compliance report was placed before the court.
That's also something altogether different.
They don't know what to do with this matter. You
My lord, in my humble assumption, my lord, I'll
find
place those
we'll
orders.
find a via med-
My lord, I'll place those orders where their petitioners, my lord, they've come by way of a separate writ petition. Orders have been passed in their favor, my lord.
Maybe if taking, anyway, we will not say anything. No tentative view.
Our humble submission would be, my lords, I think I can speak for my learned friend also. Merely because, my lords, there are 3 petitioners in a writ petition. If 2 decide to, my lords, take a certain my lords, option, that would not preclude the 3rd petitioner to exercise the 3rd option, provided it is maintainable in law.
So maintainability in law is the question.
Contempt is maintainable in law if
it
if
was
an
filed
order is
in-
not complied, where else
It was
do I go?
filed in time, my lord.
After 4 weeks, my lords. We'll
Die
try to
down,
work
my lords.
out.
I pray, my lords, lordships may have it sometime after next week. Let us make an effort to close this matter. 2015.
See, this court is practically fed up with this matter. That's why I listed today also with the intention of,
closing,
giving last rights, whatever happened.
But in my humble submission, by giving them liberty to file an appropriate writ petition, my lord.
Deep down, my lord, the respondents also.
Already got it taken away.
My lord.
May I pray, my lords, may I have it next week. We'll try and make an effort, my lords,
So just
to
give the
assist
list
this
of the-
honorable court
Just
on
give this
how,
to the
what would be
petitioners,
the way
yes.
out.
It is out for 2 weeks. This matter of 2 weeks to enable the learned DSGI to come up with details of the independent
Writ petitions filed.
writ petitions filed. Yes. Then
And
we'll
also
do a
they'll come
small-
out with the list of the directors of Assam Rifle for last 10 years.
On that relevant date,
That-
we'll have the list.
And also the person.
The roll of honor for last 10 years.
No. The concerned DG was in office on 23/8/16.
Show me the
Yes.
affidavit that you filed, it is there.
16 का एफिडेविट में
It is there.
On 16.
नहीं एफिडेविट कभी डीजी ने फाइल नहीं किया लॉ ऑफिसर ने फाइल किया मैटर में
DG is filed.
प्रॉब्लम वही है
A number of
DG is
evidence
not
filed.
filed.
डीजी आर
DG
नॉट
is filed.
फाइल्ड
DG is
दैट इज द
Well, the other difficulty is, well, in contempt, some law officers filing an affidavit. That shows the scant regard that these people have for this court.
The DG had never
That
filed it.
affidavit was filed some 7-8 years back. So I don't think
All the more
it's time barred to raise their objection also, my lord.
Yes.
He saved his skin, my lord, by putting the law officer forward. All along, the law
Those
officer has been
those
filing
objections were required to be taken at that point
No,
of time.
we
The
had
affidavit
taken.
was
We had taken.
Okay. At least after 2 weeks. Yes.
My lord.
27.
Pray for 3 weeks only.
27 together, my
3 weeks only.
Okay, 3 weeks.
Oblige, my lord.
Oblige.
Item number 34.
This matter, my lord, if it is, may I pray, my lord, if this matter is listed next week, my lord?
Why?
I have some difficulty today, my lord.
Why difficulty? Start. We will help you. Yes. As it goes along. You're correct respondent.
My lord, I am respondent number 4.
Then she is there.
Respondent number 3, Your Lordship.
Who's for the state?
State.
Good. You ready?
Mr. Sen is ready.
Yes. This is a acquisition matter.
It's a promotion matter,
No,
madam.
this is promotion.
Denial of
This is-
promotion.
this is
with
not
writ
promotion,
petition.
actually, my lord.
Supersession, that is the alleged
This is not promotion.
Brilliant.
He is challenging the post of the
MD,
MD, my lord.
Managing Director.
This is not promotional.
It's a you post. It's retrospective seniority.
My lord, it's a private respondent
Because
number
some
4.
people have retired, if I remember correctly.
No,
You
my lord,
have 4 retired.
My lord, in
Respondent number 4 is,
in
I
this-
think still
He's
in
the
office.
promotee.
They have challenged his
my lord,
appointment
for the
as
post of
MD.
MD, my lord, 3 names were forwarded to the government. One of I was appointed as the MD, my lord. He is
Who are you?
challenging that.
He's
I am also one of
respondent
the.
number 4.
I am respondent number 4, my lord.
4 Delini normally.
He's the promotee, madam.
Then who's
He's
Gerald
not promoting,
Kindia?
my lord.
Jerukinja is the outgoing MD. Your Lord.
Who's appearing?
I'm appearing.
He's retired.
He is retired.
So strike him out.
No, they have made some allegations against him also.
What allegations?
Allegations is that I do not place certain records in office. But I have, my lord, I place them before the board.
Now this teach already retired poor fellow, drag him here. How do you extract from him? Do those people in MIDC get pension?
No.
Yes, what are the grounds of your challenge?
My lord, the writ
Just
petitioner,
because it's not ready, just if it
writ
doesn't
petitioner is senior to the promotee, the private respondent number
have,
4.
that means 4 and 5.
Especially
Here which
4.
we joined before that.
My lord, I joined before.
What about, is it merit come seniority or seniority come merit?
My lord, here the service rule do not spell out, but the department has said that they do not prepare the upper or the
No, but does the
This is not a
appointing
post of
authority
promotion,
have the the latitude and
Madam,
discretion to have a merit kind of appraisal
My lord,
of
the
kind of
well, the
the
practice there in the department is said, my lord, two channels of appointing the post of a managing director. One is outside the MITC employees. They can appoint anyone. But when it comes, second channel is appointment from the senior employees from the MITC itself. So when they pick up from the employees itself, they always follow the seniority throughout.
convention.
Yes, convention and
Conventions are enforceable.
that is true, my lord. But my lord, they follow, and they admitted that they did not prepare any APAR to assess the suitability of any candidates. So they follow the seniority only.
So your case is that in this case they didn't follow seniority.
Yes, yes.
Pick and choose.
Yes.
That's
I'm,
not true.
I'm senior to
Our
him.
case is
I will
that-
show. I'll show in record.
He is not the senior. He
I
is
will-
not
I
the
will
All
senior
the
most
three have been
also.
appointed on the same
He
day,
is
my
not
lord.
the
I'll show.
senior.
All the promotions.
I think
My
my
lord, I
file is
still have
prepared.
some difficulty, my lord, today.
Since my file is
If it
ready,
is taken
I
up
can
next,
proceed.
next week, I am ready, my lord. Some personal difficulties, my lord. That's the reason.
We have plagued with adjournments in this court. Yes. What to do?
My lord, otherwise I'm ready. Monday or Tuesday, subject to lordship convenience.
My convenience, I'm here. I'm convenient right now for this court to do.
Right.
Next week, any day, my lord.
Okay, we post it on any day if that's your prayer. No, due to the personal difficulty of Mr. K.P. Bharadwaj arguing to counsel for upon a number 4 list this matter for 1 week. We'll finish it off.
Yes, yes. Duly obliged.
Item
Come, sir.
number, item number 36.
Can
Yes,
we have
start.
this matter next week, my lord? Can we have this matter next week? I'm praying.
Why? See, today Mr. Abraham is ready. Regarding electrocution?
Yes, my lord. Not electrocution, my lord. It's regarding the electricity, my lord, which has been denied to me despite having received the requisite payment from you, my lord.
Till now, no connection.
No connections are there, my lord. I've managed from my neighbor, but I want to have a connection of my own, my lord.
Yes, what is the case about? Are you? It's after the private part.
I'm for 124, Your Lord.
So what is the dispute? Oh, sorry.
No, my lord,
Are you saying you're the owner in possession?
Yes, I'm in possession, my lord. I'm one of the legal heir. Not owner, my lord. I am the owner by way of succession. Of course, my lord, the land in question was originally in the name of my father, my lord. Now it has subsequently, upon his death, my lord, it has devolved upon the other legal heirs, including me. Now, my lord, I am in possession of a particular area, my lord. And
Area or portion of the house?
Portion of the house, my lord.
Yeah.
With regard to that, my lord, we had a certain understanding with the private respondent, my lord. And we allowed them to construct the building. Now, my lord, on a condition that subsequently after construction, I will be relocated in a new building, my lord. And I'll be provided with certain areas of the building. I mean, certain rooms in the building, my lord. That was not done, my lord. And, my lord, in fact, what they did, my lord, the private respondent was disconnected the electricity, my lord, from my premises. Now, my lord, we had also filed a civil suit before the trial court seeking partition of the property.
Civil suit now.
It is going on, my lord.
Then you take your remedy there.
No, my lord, I did file an application seeking restoration.
Yes.
In fact, there was an FIR filed to that extent. My lord, I did file an application. That was dismissed, my lord, on a ground, my lord, that the learned trial court held that the property in this is not is a property different from what is there in the dispute in the title suit. My lord, that was completely, be that as it may, my lord, I have no qualms with regard to the orders. My lord, thereafter, my lord, in order to have, my lord, section 43 of the Electricity Act only, my lord, requires a person to be in possession of the property to have the electricity connection.
Yes.
Now, admittedly, my lord, I am in possession of the I'm in possession of the property that the respondent do not deny. Now, my lord, I applied for the connection, my lord. That was allowed. Inspection was done, my lord. I was informed to make a certain payment for installation of the electricity meter. That was done, my lord. On the day when the government officials came for restoration of the for for electricity connection, the private respondent raised an objection saying that they cannot do it, so on and so forth, and they put a hindrance to it. Now, the government official, they returned saying that you please make arrangement for us to do the needful safely. Now, to that extent, I filed an FIR also, even FIR, the private respondent did not act on it. Now, the only question that remains is, if the law says that I am required to be only in possession to have an electricity connection, when my possession is not disputed, whether the private respondent, at the instance of private respondent, whether I can be deprived of a basic amenity, as in this case of electricity,
Yes. Now what's happened to the suit?
The suit is going on, right, Ernest?
Now the thing is that you say you are claiming your title from your father.
Right. In fact, all of us, including the private respondent. I have certain judgments of the Honorable Apex Court, as well as the Calcutta High Court, which squarely fits in my situation.
Yeah.
And then, the reason why I have come before this Honorable Court, is a question of basic amenities.
Where is this property situated?
Bishnupur,
Okay. This family agreement, see, it says that she'll be, now this land, we can't go there. Yes, Mr. Sen, what's the problem? One alarm have connection?
Whatever is being stated by my learned friend is factually incorrect.
Yeah.
Absolutely incorrect. There's a family settlement between the parties on the basis of which I have filed an application before the learned trial court for drawing up a compromise decree. They don't participate in those proceedings. Now, he's saying that the trial court is proceeding with the case. They are making every attempt possible to delay the entire trials, the proceedings before the trial court. They made an application before the learned trial court for reconnection. That was rejected. Thereafter, they did not file any appeal. And they've approached this honorable court. Now, there is an understanding between us that for a particular period, they'll be allotted a particular portion of the premises for their occupation. That entire period is already expired. They have to vacate the premises.
And where will they go after that?
That's up to them. This is the family settlement.
So they don't have part of the property at all?
No, my lord. The terms of the family settlement itself are very clear.
So, Mr. Thapa?
No, this family agreement does not include me as a signatory. It is between my forefathers.
You're bound, if you're claiming a time for fathers,
no, my lord, it is only with respect, my lord, it is only with respect to the division amongst themselves, the three brothers.
So you derive interest from which brother?
I am from one of the, my lord, I am from Motilal Sonar.
Okay. Schedule B.
My lord. Yes.
So there are 4 plots.
No, my friend is referring to a different agreement. I am referring to the agreement at page 126.
There are 2 agreements.
Hello. This is a settlement agreement between the parties, which was executed very recently in November 2017.
126 is not here.
Sorry, my affidavit. The affidavit in opposition filed on behalf of respondents.
Not inclined to take it up.
8 to 12.
The thing is that you go for appeal before.
My lord, I can't even go, my lord, because here I am on a different footing, my lord. Here I am not aggrieved by the trial court's order. What I am aggrieved by is the actions of the government respondent, my lord. My lord, the government respondent admittedly are not parties in the civil suit. I cannot file an appeal against any inaction on their part.
But what your lordships will have to also examine now is the bona fides of the petitioner and what all he has disclosed, what all she has disclosed in her writ petition. If your lordships have page 126 of the affidavit,
yes,
please see the first party. This is the petitioner.
Yes.
And then please look at page 128, clause 4.
Yes.
The first party hereby states that she has no claim whatsoever in the landed property located at so-and-so, by lease agreement dated so-and-so, and shall not make any claim whatsoever in respect thereto. So in view of this settlement, we filed an application before the learned trial court to drop a compromise decree. Or they no longer participate in that case.
You don't participate in the settle suit at all?
No, my lord. It is in fact my suit.
I'll take your lordships. Whatever
it is
date,
in fact my suit.
lordships will take it up.
My lord may have it next week, my lord. We can disposal of.
Who's not inclined to? If it's a civil dispute, why should we dabble around in?
No, my lord. Here, I'm not, my lord. I'm not seeking your lordship's interference insofar as the right of, insofar as my lord, my right, title, and interest over the property is concerned.
Is, it is called it's an offshoot of your dispute only.
No, my lord.
Of course.
No, my lord. The facts are different here. My lord,
in simple case of being occupation of some premises way been deprived.
My lord, even a trespasser is entitled to a right, right of electricity.
But in this case, look, peculiar.
Here, I am the legal heir of the legal heir of the person.
In prima facie, we see you say we have no right. I'm going to make any claim.
But that is with regard to my lord, until that right is decided, my lord, I am entitled to the electricity connection.
Right. That's you're willing.
My lord, I may fail. Subsequently, I may fail. My lord, until that moment, my lord, I am entitled to the right of electricity.
Okay, we'll see after 1 week.
1 week.
Obliged. Can't do it today. Yes. Are you ready today?
My lord, I only want to place some judgment, my lord, which of course.
Okay, 1 week.
Obliged.
Item number 37.
Well, this is a matter concerning that Maxwellton compound. There are some other developments as well, Melody. I think some other proceedings have also been initiated.
Developments keep on developing in this property.
I just wanted to get some instructions on this. Let this matter come up after 3 weeks, Melody. I'll obtain instructions.
Yes.
Yes, Your Lordship.
Some petitions been filed also for acquisition.
Yes, yes. Some other cases.
By who the lawyers?
That other case is
Krishna Barua, Melody.
Krishna Barua.
I'm told Krishna Barua is before your lordship.
So you get instructions from him for this development. Yes, after 3 weeks, as consult with some developments in the matter. Yes. And then,
life.
39. May I please, Your Lordship? Lordship, regarding item 39, Your Lordship, I am here to receive instruction, Your Lordship. I have communicated on 30th April, Your Lordship's order, and I am here to, today also morning I have sent them message, Your Lordship. I am here to receive instruction regarding finalization of the Meghalaya Social Welfare Draft Rules, Your Lordship. So I need, this case also I need some more time, Your Lordship. Unless it is finalized.
1 week.
3 weeks, Your Lordship.
1 week.
3 weeks, Your Lordship. Please, Your Lordship,
Yeah,
1 week. 1 week.
Your whole government brief is your duty to inform also with orders.
I have already.
That was later after the order.
No, this order, Your Lordship, instantly. It was order dated 29th April, Your Lordship.
Next.
Much
40. Item 40. My lord, this matter may can take up next week, my lord. I need to file a...
From your chamber, all the hearing matters are piling up now. But only eating only
This
fresh.
is a legal aid
Only
matter,
fresh. Oh, it's legal aid. Okay. Start.
This is my friend's matter.
Yes,
Praying
start.
this matter will be taken up next week, my lord. I need to file the rejoinder, my lord. I've not been able to contact the...
Who's appearing for the respondent?
For private respondent.
And for the manager.
What is the case about?
My lord, this is regarding non-payment of salary, my lord. The petitioner had served since 2004 till 2022, my lord.
Yeah, for
She
the
has not
school.
been- Yes, ma'am.
Managing committee.
She never worked in the school, according to you.
She has worked till the year 2017, Lordship.
You paid her,
Paid her. She's
No,
not
ma'am.
even a sanctioned teacher, Lordship.
but you avail of her services.
We had availed and we had paid her also, Lordship. Now she has come to court after 20 years, Lordship.
Anyway, you filed a joinder then.
My lord.
Yes, MS Adatan, the Legal Aid Council. Please have to file a rejoinder. List next after 1 week, 2
My
weeks
lord, up to 1 week.
in the order column.
It's been more than 3 times, but
Doesn't matter, legally it matter, we'll see. We'll close it next week.
Item number 42. My lord, in this matter, my lord, they have filed the affidavit, my lord. I need some time to file a rejoinder, my lord, to that.
What affidavit was filed?
It's for, my lord, that survey has been done and, my lord, some report has been filed.
Where's the actual affidavit on record?
Yes, Lordship, we filed on the 19th of June.
19. It was just last week.
My lord, on Friday.
What does it say?
As per the report, my lord, it says that it's fall under the defense.
Entire
law.
property.
My lord. So I need some time to file a rejoinder to this affidavit.
It appears, my lord, he has a shop.
No, since when this shop been there a long time.
The front portion is in same million land, my lord. The back portion of that falls in defense land, my lord.
How big is the plot?
3%.
The survey was done recently.
My lord,
My lord.
this has been done recently.
During the course of the proceedings.
My lord.
Okay. It's sitting right on the
Border.
right on the wall.
My lord.
On the boundary.
Yes.
Okay. You want to file a rejoinder?
My lord, I need to file a rejoinder.
Yes, MS Adata submits that to the additional affidavit filed by the respondents. We be allowed to file a rejoinder. Prayer is allowed. This line. This up to 2 weeks. Yes.
My lord, the interim order may kindly be continued.
Interim order when it shall continue.
Item number 43.
Item number 43. May I please your lordship?
Yeah.
Lordship, the petitioner is a private company limited here, who is basically a facilitation center under the Rule 2CD of the Motor Vehicle Rule,
Okay.
which is amended in the Section Rule 2CD of the Motor Vehicle Amendment Rule 2021, my lord.
Motor Vehicle Act and rules. No, rules.
Rule 2CD of Motor Vehicle Rule, which has been amended in the year 2021, my lord.
Wait, rules. Motor vehicle rules.
Which has introduced the concept of facilitation center, which can act on behalf of the motor vehicle owners.
Okay, yes, where you quoted the rule. Let's see.
Rules 2CD of the Motor Vehicle Rules Amendment 2021.
Wait, we're not getting the book. Wait 1 second. Rule?
2CD.
No, yeah, later one. This is 2020. Then I did one after 21. So there's one unamended one. Wait. Rule?
2CD, your lordship.
Definition. Inserted 21 CD.
Yes, your lordship. 2CD. Rule 2CD.
We don't have it here. The amended one. You have the Mr. Sinkan?
No, my lord. I have that prior.
After a week, yes. You just get the book ready, yes. After 1 week, yes.
Oblige, your lordship.
Oblige.
You get the amended one also. When you local council to produce, if local council argues, tell it to come with the materials. If it's citations or it's a rules that are applicable, it'll help your case only. It's faster. Otherwise.
Oblige, your lordship.
Oblige.